welcome to 20 Minutes. I'm Nadia Naqi with you. We have legal expert Ahmed Pansota. He's the advocate of the Supreme Court, and we shall be discussing the relief given by Islamabad High Court today in Toshakhana case to PTI's chairman. Whether it is actually a relief or not, is it a norm? And this was a delayed decision that was much awaited. That's all we're going to be talking about. Thank you so much for joining us, Ahmed. So is this a relief as being said by certain circles in the PMLN? Or do you think this should have been, this sentence should have been suspended long back?
You see, it all depends on how you define the word relief here. You see, as lawyers, we are so used to ascribing definitions to a word. So as far as the actual relief is concerned of, being relieved in a criminal trial, of course, it has not happened because the final outcome of that appeal is yet to be made. However, partially, this is a relief because the sentence has been suspended, and assuming that Mr. Imran Khan gets bailed out in other cases and he was not behind bars in other cases or was not arrested in other cases, then of course this would have been a very important relief. As far as a criminal appeal is concerned, suspension of sentence comes across as a very, very important relief because this is somewhat an alternate to bail post-conviction. So yes, as far as this case is concerned, we can safely state that his conviction is still there. However, his sentence has been suspended.
Okay, there was a lot today said about his disqualification because earlier when the trial court had convicted him, his opponents, that is PTI's chairman's opponent, had been saying that now he is disqualified for a period of 5 years, which means that he cannot hold public office and therefore he cannot hold elections. I really wanted you to comment on this.
Well, as far as disqualification is concerned, that is primarily done on the basis of conviction. Like I said before, that conviction stands, and conviction has not been, set aside. As far as I've not examined the order completely. It's not out in the public eye as yet, but the conviction stands. And disqualification is usually made on the basis of conviction. But the interesting aspect can be because the lawyer, Mr. Imran Khan, had specifically pleaded that the order should be suspended or the judgment should be suspended. So if the Honorable Islamabad High Court goes in that direction and suspends the judgment, then I think he's got a chance that his conviction will also be suspended. But generally speaking, in criminal appeals, because this is not a case which is being decided in writ jurisdiction, which is the constitutional jurisdiction, and judges have a wide ambit and wide powers to exercise. This is being decided as a criminal appeal. So in a criminal appeal, for setting aside or for suspension of sentence, there is a specific provision in the Criminal Procedure Code, which is called Section 426. And that provides that you can seek a suspension of the sentence during the decision of the appeal. And when you expect the appeal to go beyond a period of 6 months, which this is going to take not because the judges don't want to decide it till then, but because there is a backlog of cases. And generally, whenever a suspension application is taken up, ordinarily in cases which involve sentence below 5 years, and this is, of course, now 2.5 years after the latest remission by the president, so they are usually suspended. That's a practice.
Okay, so this is very interesting. The judgment is not suspended. It is only the sentence that has been suspended. Now, let's move further. Everybody was expecting that there's going to be a release order very soon, and Chairman PTI is going to be out of the Attock Jail, which we don't see happening because we just know that he has been booked in the cipher case according to the Official Secret Act. So what do you do then? What are the lawyers supposed to do?
Well, this was probably one of the biggest fear of Imran Khan's legal team when several cases were being made against him. And now I think we cannot even use the word several. It is, I would say, a large number of cases, almost 200 cases against him. So he was being very candid and he was being very professional as far as his legal strategy was concerned. He was appearing before all forums, and somewhat he had managed through able legal representation, I would say, that he was bailed out and he was not sent behind bars. So this was the first case where, because of the conviction, he had to go behind bars. And once this happened, of course, prosecution in all other cases had geared up. His bails were dismissed. So once his bails were dismissed, then prosecution is at liberty to arrest him. So now it is going to be a cycle that will continue for a while, unless there is an extraordinary relief from Islamabad High Court or the Supreme Court that Mr. Imran Khan was on bail before he was convicted, and he could have appeared before the court if he was produced before the court. So keeping those circumstances in light, he should be once again released on ad interim bails in cases that he was already on bail. So this is going to be a tricky situation. But if it doesn't happen, then Mr. Imran Khan is slightly up for some more incarceration, I would say, as it just happened, because just when he was about to be released, there was an order which was brought and his arrest was made in the cipher case. So once he's through with the cipher case, then it's going to be the Lahore 9th May case. Once he's done with that, it will go on and on, unless there is an extraordinary relief. And I believe if at all any extraordinary power should be exercised or must be exercised, it is this case. Because whenever you compare Mr. Imran's case with an ordinary citizen of Pakistan, that rhetoric that we have to hear that an ordinary citizen has to go through all of this in Pakistan. Why is it different? Well, my response is always the same, that an ordinary citizen in Pakistan is not supposed to go through 200 FIRs, because he'll at max be exposed to 2 or 3 FIRs, which is the actual case. So the situation is extraordinary, requires extraordinary measures. Therefore, I believe some court must come out to his rescue so that he's allowed to contest his cases. And the cases should be decided on merits.
When you say that some court must come out for his rescue, Imran Khan's opponents keep on saying that the incumbent Chief Justice is always there for his rescue. In fact, there was a lot of hue and cry regarding the remarks that the Honorable Chief Justice had made regarding the trial court in the especially in the Toshakhana case, saying that the prima facie it looks that the judgment is not correct, or probably he's not been given a fair chance.
I would have considered this critique important and response-worthy if the same was made about the Islamabad High Court Chief Justice as well by the same quarters. Because if the criteria before making this critique is that there were comments which were made, or Chief Justice is always there to his rescue, then the suspension of sentence was made by Mr. Ahmed Farooq. Mr. Ahmed Farooq also commented and said that trial court decided this in a very hasty way, and there were several other comments made about the trial court as well. Then why are the comments by PMLN only targeted against the Chief Justice Pakistan? I will now come to that particular aspect where he made these comments. You see, we need to understand there is a background to that. When this case was going on, the jurisdiction was challenged before the trial court. It was dismissed. It went before the Islamabad High Court. It was sent back to the trial court. Trial court dismissed it again, and it was sent back to, obviously, appeal before the Islamabad High Court. It was that order whereby it was remitted back to the trial court that the PTI lawyers had challenged on behalf of Mr. Imran Khan before the Supreme Court. So the Supreme Court had just 2 questions to answer, or to ponder, or to at least sort of comment on, adjudicate upon. And those 2 questions were whether this was done beyond 120 days, and whether the Secretary Election Commission of Pakistan is capable of being termed as Election Commission. And Supreme Court said prima facie, it appears that on both these counts, Chairman Tehreek-e-Insaf appears to be right. And this is exactly what Islamabad High Court said. So yes, judges are supposed to make comments. And this trial, which of course I am 21 years into practice now. I've done so many trials, criminal and civil, both. I have never seen any trial of this sort where you are seeking permission to file your defense. You bring in your witnesses, you want to produce them, and the honorable judge says that no, these witnesses are not relevant. This relevancy is only to be decided once a witness has been examined and cross-examined. Then you're in a position to say, okay, this testimony was relevant or not. How can you say, if I level an allegation against you and I say I want to produce a witness, how can I say this witness is not relevant? So this trial in itself was a sham. I always call it a sham trial. And this trial should not have been conducted like this in the first place. And I don't know why was it done this way, because if they were genuinely serious about going against Imran Khan Saab, then I think there were several other ways of doing that. At least bare minimum could have been Article 10A, due process should have been guaranteed.
Okay, so now this Toshakhana case is a bit of complications, because as you just mentioned, that Secretary Election Commission is not actually Election Commission per se, right? And he did not have the right to file a case against Chairman PTI. So this is one thing that the legal team would be contesting, I'm sure. And the other one, that 120 days had passed when this case was filed.
So you see, there are two ways. First of all, if there is to be a case which is to be filed under this law, it has to be filed within 120 days from the date of filing of your returns. This case was filed at least 7 months after the filing of returns, number one. Number two, if this case is to be initiated, it has to be initiated by the Election Commission of Pakistan. Now, Secretary Election Commission cannot be termed as Election Commission of Pakistan. These are the two basic, I would say, the facade of this case rests on these two important points. Now, I will bring you to how Supreme Court deals, or the superior courts deal with the issue of limitation. We appear every day. I'm a regular tax practitioner. I appear on behalf of FBR. There have been cases when we appear before the Supreme Court, the files are usually put on the left-hand side. And the first question that is posed to us is, gentlemen, do you know that this is about 6 days time bar, 5 days time bar, 1 hour, 1 day time bar, and we have no answer to that. So unless we come up with a cogent justification, and there is no cogent justification in law for limitation, for violation of that, ordinarily it is dismissed. So the foremost question that was posed by Chief Justice, or the observation which was made by him, that you're prosecuting the ex-Prime Minister of Pakistan on a law which provides for a time limitation and for the initiation to be made by a particular office. And both of these things were not done.
Right.
Just leave alone. I will not be commenting on the way that trial was done. That's a separate story. That's a complete nightmare. But this particular aspect was not adverted to at all.
All right. All right. So now what happens? This is stage one, that the sentence in Toshakhana case has been suspended. What is stage two? There's going to be a trial in the Islamabad High Court. I mean, or are we expecting once again that the case is remanded back to the trial?
You see, appeal is usually referred to as continuation of proceedings.
Right.
Once a trial is decided, and since this is a criminal trial, even in civil cases, you file appeals or you file revisions. In a criminal trial, this is a case where an appeal was preferred, and appeal is continuation of proceedings. So the appellate court, which is a divisional bench here, is in a position to completely look at the case as if the entire case is before them in all respects. So they can examine the evidence, they can examine the jurisdiction points, everything, the entire judgment can be examined. So this case will be examined. And most likely, I feel that once the final decision is made, the judgment will be set aside and will be remanded back to the trial court to conduct it properly. Because usually trials are conducted properly, and then you sort of...
trial court, you mean? I'm so sorry to interrupt you. To the same trial court in front of the same judge?
Not the same judge, but the same trial court, because the judge has recently been changed, as I think somebody informed me. He has been made OSD. So it's going to be the same trial court. But the real question is, at times there are cases where the judges remand the matter back to the trial court because the trial is not conducted properly. The requirements of law have not been fulfilled. But then there are instances where the entire thing is on the point, but some legal point is not construed properly. But here I feel that the matter will be remitted back. The judgment is going to be set aside for sure. That is a writing on the wall, because I can very clearly see that happen. Not because of the way this bench is dealing with it, but because of the way this trial was conducted.
Okay. Now, there's a lot of, not about the merits of the case, but let's talk about the legal fraternity, the justice system, that it is so predictable. I mean, there is so much of division, and the judgments are predictable. It is so predictable that this is what the superior court can say in favor of a person, and a lower court can also go against that same person. How do you bridge this division, and when is it? Because now every judgment is being suspected from both sides. That this is a sham judgment, this is a sham case, or this is in favor, or this is deliberately done. So what does the legal fraternity need to do to get this trust back of the people of Pakistan on the judicial system of this country?
Well, first of all, I believe that we live in a common law system and we are bound by judicial precedent. So we should be able to predict what the judgment is going to be. The real problem and the real danger is when you are unable to predict what the judgment is going to be. But the law is settled, the judgments are there, the precedent is there, you're just supposed to follow that. So we live in a system where we are unable to predict, even in that case. I mean, I'll give you an example of this particular case. We were unable to predict what is going to happen in the trial court. Okay. In the appellate court, people were not sure if this would be suspended or not. There was a sizable portion of public which was in support of the argument that it should not be suspended. As far as the judicial system is concerned, I believe the judicial system of Pakistan needs a major revamping. There is no disagreeing with that. And that major revamping includes when the judges will start speaking through their judgments, when they will not make frivolous and unnecessary remarks and comments in court, when they're bound by the law and the constitution and nothing else. These things are, quite popular and familiar that you might hear every day. But trust me, when you start doing that, it makes a hell lot of a difference. And judiciary in the Pakistan has been on the rampant. I would mainly be talking about the 2000 judiciary existing prior to 2007. They were passing all sorts of judgments. So when you have a chief justice saying that the military dictator is allowed to amend the constitution, what else do you need to proceed against him? So I think the judiciary of Pakistan is blotted because of these judgments and not because of other judgments. Plus, they have to decide a common man's case first and have to dispense justice at the grassroots before they start taking up political matters. And they must not involve themselves in political matters. I have a very, very firm belief as far as that is concerned, but it is very unfortunate that politicians want to bring everything in the court of law.
Of course, you're absolutely right. All political cases are being settled in the court of law, rather than things that could have been probably resolved in the parliament when there was a parliament. Right now, of course, we're in the interim setup. Lastly, I just want to ask you that the smear campaign that was led by official Twitter handle of PTI against the Chief Justice of Islamabad High Court, because they thought that probably there's not going to be a suspension of this sentence, which finally they got. Do you think there was a lot of pressure? Because you do remember that Chief Justice Islamabad High Court had also said that, he's become a sandwich between the Supreme Court and the trial court. And, the kind of remarks that were uttered by the Honorable Supreme Court also in this Toshakhana case.
Well, I believe that a judge, the appointment process for a judge is such, in fact, the removal of a judge is such that he cannot be removed that easily. So he should not be guided, bound by any public pressure, any public opinion. As I mentioned earlier, he should merely be guided by the law and the constitution. As far as the campaign is concerned, if that campaign is initiated by anybody against any sitting judge, that should be condemned to the core. And I will never ever support any remarks against judiciary which are prejudicial to their their conduct, which are prejudicial to their integrity. That should not be made, because A, that's contemptuous. B, judges cannot start making press conferences and reply to your comments. So then they will simply wait for a judgment where they will, of course, in a different way communicate that. So I believe one has to be very, very careful and remain within the constitutional confines before making any such loose remark about any judge, for that matter, even as a trial court judge or the Supreme Court judge, High Court, anybody, they're all equal.
Okay, and PTI's chairman, when do you really expect him to be released? It's very difficult to say, because you yourself said there are several cases against him. He's been booked in several cases. But you do understand the legal process and you do understand the political arena.
I believe, like I said before, it is an extraordinary situation for him. So extraordinary measures are required. And High Court and Supreme Court both have extraordinary jurisdiction. They have to do something extraordinary to make sure that he comes out and is able to face his cases. But how things are moving at the moment, I believe he is in for a while. And I don't know how far is that helping him legally, but politically that is helping him for sure.
Thank you so much, Ahmed Pansota, advocate of the Supreme Court, our legal expert today on the Toshakhana case. That's all for now. Take care and goodbye.